by having those assets simply owned by the trust. Death taxes, always something that clients are concerned about whether they should be or not, and so we got to be a bit knowledgeable of them. And it used to be a major deal for any of our clients that had any kind of substantial worth at all. Basically, if you had a house and a retirement account and a life insurance policy and a bass boat under the garage, you had a taxable estate, right? Because the exemption number was $600,000. Then it went to $1 million. Then it went to $2.5 million. Now we got an exemption of I think the new number is $5.4 million or thereabouts, pretty close to 5.4. At this point, it's a $5 million number from 2011 that's indexed for an inflation factor, and so that number goes up. Additionally, we have something called portability, where we're able to pull over any unused exemption for an individual that's not used by the first spouse to die. The surviving spouse gets to use their unused exemption for their own estate. So we call that portability, where we can port over any unused exemption by a spouse to the other spouse, which means for married couples, it's not a $5 million exemption, it's a $10 million exemption. And so in Mississippi, while we have some people that still face estate tax issues that we got to deal with, the overwhelming majority of people that we deal with on a day-to-day basis do not have taxable estates, and the estate tax is not something that they've got to certainly center their planning around. It's worth a discussion, perhaps, of is your estate going to likely be able to grow above this number? Is it going to grow faster than this exemption number is? But by and large, for the most of our clients, that's not going to be the key factor and the key element in managing their estates. A couple things you need to know about portability, by the way, and especially for the benefit of your clients. Portability is not automatic. It only applies to spouses, and it only applies if you file a timely estate tax return. So the spouse dies, you got 9 months to file a return that says, all the assets fell within the marital deduction, and so there was no assets, that went into their estate, therefore ports over the entire unused portion of the estate tax, estate tax exclusion amount to the surviving spouse. If we don't file that timely return, you lost it. And so our clients need to know that, and whenever you're delivering these checks for the life insurance proceeds, it's something you might want to mention to the surviving spouse is, do you want to, you ought to check with your CPA, or you ought to check with the lawyer handling the estate to determine whether or not you want to file a 706, whether or not you want to file that estate tax return, not because any taxes are owed or because we think there might be potential for tax, but because filing that piece of paper lets you preserve that exemption. Is it going to cost some money and be a little bit of hassle? Yeah, you got to provide certain things to do that. You got to pay the accountant to prepare the return. But is it worth it if you wind up with a taxable estate 5, 10, 15, 20 years down the road when that second spouse dies? You bet. And at a minimum, you're going to want a piece of paper in your file, because when surviving wife/mom dies 20 years later with a taxable estate that was like $7 million, just cost the kids about $1 million in taxes, they're going to come to you and say, why didn't you have mom file that return? It'd be nice to have that letter in there saying, I advised her to do that and she chose not to, rather than nobody saying anything to them about doing that. We're advising all of our clients whether they have taxable estates or not. If they have an estate that has any likelihood at all of exceeding that exemption for that individual, to go ahead and file the return so we can preserve that exemption going forward. Some do and some don't. Most of them do, especially now with land that we thought was worthless and now suddenly has minerals underneath it that you can actually get affordably by pumping a bunch of chemicals down to the ground. Suddenly people that wouldn't have taxable estates are going to have taxable estates, and they're going to want that exemption. They play the lottery and win, they may wish they had that exemption as well. So it's better to file that exemption and not need it, I think, than to lose it. But portability is out there, which also gives us a lot of flexibility from a planning perspective, not having necessarily to create A/B trusts, not having to create this division of trust between husband and wife. We still do it from time to time, but we don't have to preserve the exemption, is my point. There is an unlimited marital deduction, so if we have assets all going to the surviving spouse, we've got no problem or no issue with respect to being any tax. By the way, that unlimited marital deduction only applies to citizen spouses, and so if you have a client that is married to a non-citizen, there's other types of planning that we need to do if we're worried about that exemption. But for the overwhelming majority of our clients, they're not concerned with the state taxes. We're not concerned with the state taxes. That's not the centerpiece of the plan. There's still other reasons that they need to do planning, though. There's still issues of the surviving spouse and protection of that surviving spouse. There's still issues of surviving children and maybe protection of the surviving children. A lot of stuff can happen after someone dies.